yea. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Well, good morning. We are delighted to be here at Belmont University College of Law for, our annual appearance here, it seems like. So, this will be live streamed on the internet as well. So, just want to remind council that whatever you say goes out everywhere and stays there forever. So, you might want to be careful. We have two cases on the docket, and we will hear them in the order in which they appear. If there are no announcements or questions, would you call the first case, please?
Ralph Ray Bailey, personal representative of the estate of Roberta Bailey versus Sonya Smith Wright, Executrix, estate of Vondie Lee Smith.
Good morning, Your Honors.
Good morning.
May it please the court, I'd like to reserve 3 minutes for rebuttal. First, I'd like to thank the panel and thank Belmont for having us here today. My name is Garrett Englund, and I and my co-counsel, Mr. Hugh Green, represent the appellant, Ralph Ray Bailey, as executor for the estate of Roberta Bailey in this will contest action against appellee Sonya Wright. This will contest concerns the validity of the last will and testament of Vondie Lee Smith, dated February 16, 2017. Although we've raised a multitude of issues on appeal, the central issue in this case is the trial court's failure to instruct the jury that a presumption of undue influence arose as a matter of law because of the attorney-client relationship formed by Ms. Wright's preparation of Vondie Smith's will and because of Ms. Wright being named as a primary beneficiary in that will. We submit that the trial court should have shifted the burden of proof to Ms. Wright to prove the fairness of that transaction by clear and convincing evidence. Now, there was abundance of testimony that was presented at trial, but the key facts that are pertinent to this appeal were undisputed. In the fall of 2016, Ms. Wright, a practicing attorney, met with Vondie Smith at her home, where she received 2 unsigned wills with handwritten changes, one for Ms. Smith and one for her husband, Dan. Ms. Wright agreed to take...
Counsel, the will that was ultimately signed here, are there any additions, changes, alterations between what was the written comments upon the will and the final version? So when Ms. Wright had this put together back at the office, are there any substantive additions or changes beyond what was already written?
Yes, there were, Your Honor. So the original document with handwritten changes contained only 4 sections. It was a very simple will that named the executrix and the beneficiaries. The handwritten changes purportedly listed Ms. Wright as the executrix, changing it and naming Ms. Wright and her husband as primary beneficiaries.
And weren't those included though in the handwritten
That was
notes
included in
themselves?
the handwritten changes.
What about beyond the handwritten notes themselves?
So
Are there any other
will
additions or changes other than the handwritten ones?
Yes, Your Honor. So the will that was ultimately produced had 8 sections, and one of the most predominant changes that came out was a no contest provision that was included in that will that stated that any party, including a beneficiary who contested the will, would be disinherited, and their inheritance would pass to the remaining beneficiaries. So in this case, we actually raised that issue at trial because Roberta Bailey and now the Baileys were contesting this will, and an argument was made that if the will was upheld and the no contest provision was upheld, then the Tarpley farm, which they were to inherit, would also pass to Ms. Wright along with the original inheritance.
Counsel, your argument on appeal, you have a challenge both as to the summary judgment aspects of this and as to the jury instructions aspect. I want to pull out the summary judgment side for a moment, and we talk about the jury instructions after. But
yes, Your Honor.
With regard to the summary judgment piece, my understanding is, and you're essentially saying that there should have been an instruction with regard to presumption, and there was an error in failing to grant that at summary judgment stage, and that as a matter of law, the presumption couldn't have been overcome, and that was, you're arguing both errors as to summary judgment and instruction with regard to both of those pieces.
Yes, Your Honor.
With regard to the summary judgment aspect of this, Did the trial judge make the determination to decline or deny summary judgment based upon an understanding that there were material disputed facts?
No, Your Honor. In fact, what happened was the summary judgment was filed originally, and we requested that there be a presumption because of the attorney-client relationship and the benefit that was to be received. We actually, prior to the trial, filed a motion to revise. When we went to the pretrial conference, the court welcomed that and said, I want to reconsider these issues. We held a follow-up hearing, submitted additional briefing, and the court actually submitted an order that revised the summary judgment order to reserve ruling on the existence of the attorney-client relationship as well as the existence of a presumption of undue influence. And in fact, this reservation on the ruling was held pending further proof at trial. And the ultimate ruling wasn't actually made until the end of the trial when the court made its ultimate determination as to the fact that there was an attorney-client relationship and refusing to rule that there was a presumption of undue influence. So this decision kind of almost occurred concurrently with the point where the judge made the instruction to the jury as to these matters.
Are they two different issues then, or is it one issue? Does this really all fold into the instruction?
It really all folds into the instruction, and I think that's where we kind of end up at, is this is a distinction without a difference, because what we're saying really, the zest of this whole argument is that we've raised this issue from summary judgment up to pretrial, up through trial, and post-trial, but ultimately the judgment kind of occurred at the same time. So there's really, we're kind of addressing both, and that's the reason why if you see in our brief, there's only really a 2-page sort of addressing of the summary judgment and then getting into the bulk of this, which is the trial court made this determination there was no presumption. That was an incorrect conclusion.
In pretrial, did you propose an instruction that included the presumption in it?
Yes, we did, Your Honor.
And that was rejected by the court?
It was rejected by the court. In fact, the proposed jury instruction number 2 and 3, if I recall correctly, one proposed that there would be a presumption of undue influence, and then we proposed a third one with regard to rebutting the presumption, stating that there was no independent legal advice provided to Ms. Smith.
So the alternative instructions you proposed about whether or not Ms. Wright was active in causing the will to be made, that was after the court had rejected your previous jury instructions?
That's correct. Once it was clear that the court was going to rule that there was no presumption, our choice was to address the instructions to the jury that we came up with, or that the court ultimately agreed to, based upon his ruling on the presumption. And as stated, what the court actually instructed the jury was that there would be a presumption of undue influence only if they found that Ms. Wright was active in making the will to be procured and executed and that she benefited from it. And our argument here today, the most central issue in this case, is that that was an incorrect conclusion of law. Now, Tennessee law on undue influence is well established. In order to find undue influence, you have to have a confidential relationship, i.e. there is a dominant party and there is a weaker party. The Tennessee Supreme Court in Kelly v. Allen in 1977 delineated 2 categories of confidential relationships. There's the legal fiduciary relationship and there are familial or other relationships. Now, this distinction is critical to the analysis of this case because as the court in Kelly held in non-fiduciary, familial, or other relationships, the mere proof of the confidential relationship is not enough to raise a presumption of undue influence. The court held that there must be an additional showing to show dominion and control over the weaker party, i.e. some activity on the part of the beneficiary in connection with the preparation or execution of the will. Now that is for familial or other relationships. Now the court went on to clarify that these rules are not applicable to those cases where a fiduciary relationship exists, such as conservator ward, trustee-SDK trust, or attorney-client, where the law prohibits gifts or dealings between the parties. In those circumstances, the Tennessee Supreme Court in Matlock v. Simpson in 1995 succinctly stated the rule that where there is this confidential relationship followed by a transaction where the dominant party receives a benefit from the weaker party, a presumption of undue influence arises that may be rebutted only by clear and convincing evidence. Now this rule applies particularly in a situation where an attorney drafts a will in which they are a beneficiary. In 1991, the Court of Appeals in Petty v. Privet emphasized that when an attorney is a major beneficiary of a will they drafted, a presumption of undue influence arises because of the confidential nature of the relation, and the donee has the burden of showing the fairness of the transaction and the honesty of the transaction. This principle was reaffirmed in 1996 in Hager v. Fitzgerald and in 2001 in Henry Estate of Wakefield.
Now, there's no factual dispute here that Mrs. Wright's practice area was not Wilson Estates, correct?
I'm sorry.
There's no factual dispute here that Ms. Wright's practice area was not Wilson Estates, correct?
There is no dispute as to that fact.
Okay, and was there any serious challenge to the notion that Ms. Wright was going to have her law partner, or her intention was to have her law partner advise her aunt about the will?
There is no challenge to that her testimony was that was the intent. However, those things never occurred. Amy Fair testified that she never met Miss Smith. She did not have any involvement in the drafting of the will, and in fact, at trial, Miss Wright took responsibility for the preparation of the will, and which named her as a beneficiary.
Was that the aunt's choice?
Was the aunt's choice
To not deal with the partner?
Putatively, it could have been, yes, and that's what Miss Wright testified to, that Miss Smith chose not to come back. However, the standard or the requirement, especially when regards to independent legal advice, to rebut the presumption of undue influence doesn't take into account whether the client chose not to seek advice or not.
Counsel, is it limited, in overcoming the presumption, is it limited to independent legal advice, or can there be other circumstances that could be a basis for overcoming the presumption?
Yes, Your Honor, thank you. And generally, there can be other circumstances that would overcome the presumption on a broad scale in undue influence cases. However, that's the reason why we were pinpointing Petty v. Prevet and Hager v. Fitzgerald, those cases which state that when it comes to an attorney-client relationship, when that is called into question, the attorney has the burden of not only showing that there was no undue influence, but also showing that the client received independent legal advice as to the consequence of the legal transaction. And so in that circumstance, that would be the tantamount requirement to overcome the presumption of undue influence. And in fact, and as we stated in Kelly v. Allen, the law already prohibits gifts and dealings between the parties. So that's the reason why when a fiduciary receives a benefit, the law treats those transactions as presumptively invalid, pending the beneficiary's, the fiduciary's proof of clear and convincing evidence of the fairness of the transaction. And actually, this exact error was addressed in Parham v. Walker, which involved a conservator-ward relationship where the conservator was a beneficiary of the ward's will. In that case, the court stated, based on Kelly v. Allen, the relationship of conservator-ward is one of those cases where the additional showing is not required. And the trial court erred by not placing the burden of proof on the beneficiary to disprove presumptive undue influence. The court reversed the cause for substantial error and remanded the matter for a new trial. That exact same error occurred in this case. The court failed to find a presumption of undue influence. The court failed to shift the burden of proof. And the burden of proof is important here because it's a much higher burden of proof on the beneficiary, whereas the contestant bears the burden by preponderance of the evidence. Once that burden shifts to the beneficiary, it is by clear and convincing evidence, a much higher standard. And that is the exact error that we have here. Now, had the trial court had found a presumption of undue influence, that presumption could not have been overcome by clear and convincing evidence, as we stated. As stated in Petty, in any transaction when between an attorney and client called into question, the burden is upon the attorney to prove that any undue influence was neutralized by independent advice given to the client. There was no evidence of any independent advice given to the client in this case.
Counsel, can you address the evidentiary issues here, because you're almost out of time?
Yes, Your Honor.
That I'm interested in the voicemails here. I think the appellee here makes a fair point. You know, if you didn't request them in discovery, and it sounds like the bulk of them were not requested in discovery because they predated the time range that they requested, why is there error then in admitting those?
Well, we believe that the rules would require that, first of all, I believe that there was a request. There were general requests in discovery through interrogatories of any documents that would be utilized at trial, as generally there would be. But if it was the case that we did not specifically request those, it would still be the requirement that something as important to the case.
Well, was there any objection to that generalized request for anything that would be used in trial? Typically, opposing party objects to those types of interrogatories as overly broad.
I do not recall if there was an objection to that specific type of interrogatory. But again, the main gist of that is that these voicemails were highly prejudicial and used for a purpose only a couple days before trial.
Your time is up. Thank you.
Thank you, Your Honors.
Your Honor, I have a couple of blow-ups that I might use during my argument, if we could just have a second to set it up.
Has opposing counsel seen them?
I showed them, yeah, they're from the record.
Okay.
We're closer. Just lean it against there, and I'll use that as I need to. Good morning, Your Honors. Donald Caparello, Nashville Bar, along with Tyler Yarbrough and Jacob Vanson. I represent Sonya Wright in this case. Opposing counsel was asked if the trial court denied summary judgment because it found material issues of fact. And then, of course, he repeated it later on. And the answer is yes, he did. I'll specifically quote, "The court found that there were material issues of fact regarding whether Ms. Wright was active in causing the will to be made. It also held that Mr. Bailey's allegations of suspicious circumstances are in the negative or at least disputed with the exception of the attorney-client relationship." So that is why the trial court denied summary judgment, because both sides moved for summary judgment and both sides failed on that issue. Now, one important ruling on summary judgment that was not on appeal is that the trial court found that when Aunt Vondie, I'm going to call them Aunt Vondie and Uncle Dan because that's how my brief does, if that's all right with Your Honors. So, because that's what Ms. Wright called them. When Aunt Vondie and Uncle Dan went to get the will executed at Farm Bureau, the trial court found that it was properly executed, and that issue is not on appeal in this case. And that's important in undue influence cases because when you have a properly executed will, that creates a presumption of a valid will, which is why the trial court required the other side to prove undue influence by preponderance of the evidence. So we get essentially to this question that they've raised, which is that they're arguing that in every case, no matter what the facts are, if you have a dominant party who has a confidential relationship, if they get some type of a benefit and a gift or a will or something, in every case the presumption shifts. And that's simply not the law. It hasn't been the law since the Childress case came along.
Counsel, is there any dispute that the will that was executed was ultimately prepared by Ms. Wright, and that Ms. Wright essentially created this document, and the instruction in terms of flipping the presumption that Ms. Wright was active in making the will to be procured and executed, and she benefited from it? So if she's the one drafting this will, how exactly is she not active in making the will that will be to be procured and executed?
Well, first of all, the quote that they gave you about the jury instruction is not correct. This is from the transcript. This is what the jury instruction actually said. Section 11. This is Tennessee Pattern Jury Instruction 11.39. It says, there is a presumption that the will was obtained by the undue influence of Sonya Wright if you find that Ms. Wright was active in causing the will to be made.
My question remains, how is she not active in causing the will to be made if she's the one drafting the will?
Well, for a will to be made, you need, first of all, it needs to be drafted. And in this case, the first draft of the will was done by Aunt Vondie, where she decided the beneficiaries. The second part of a will, making a will, because if it's drafted, it's just a piece of paper, is you have to go get it separately executed properly, and it was properly executed in this case. So actively in causing the will to be made means both of those things. It has to be drafted, and it has to be executed. And the underlying essence of undue influence is not influence, but undue influence, which is mean you have to have coercive conduct that destroys the free agency of the testator. So here you have...
Does the word active actually appear in the pattern jury instruction?
Yes, 11.39 is exactly the pattern jury instruction.
And I wonder where the word active comes from. If you look at our decision in State of Link, we just say played a role in the making of the will. And if you look at Childress against Curry, it talks about, part of the definition of confidential relationship is it requires proof of dominion and control. Where does active or material or any of that come into play? It seems like to me that the pattern jury instruction may have departed from our case law.
I don't believe it has. After all, they had an argument in this case about whether they would use the word procure or active. And since 11.39 says active, and if you look up the word procure, it basically says active. They just sort of switched those words out. I don't think that's not dispositive of this case. What's dispositive of this case is that the essence of undue influence, which they also were instructed of, is this dominion and control or coercive conduct that destroys the free agents of the testator. So here, at the two key points that Ms. Wright could have had some dominion and control, it's when Aunt Vondie's the one that drafted the beneficiaries and said, that's what I want. And remember, it was her and her husband working together, and they both of their wills say they wanted Sonya Wright to get this stuff.
Counselor,
Yeah.
in your view, this was a question for the jury, right? In terms
Yes.
of whether, okay, if that's the case, how do we square that with the verdict form where it ends with plaintiff Ralph Ray Bailey has the burden of proof by a preponderance of the evidence? Because I gotta say, that sounds a lot like an exam where you tell the students, if it's this, then it's A, and if it's this, then it's B, but the right answer is A, and I'm only giving you the blank for a little bubble for A. So how do we square that instruction with that verdict form?
The trial court chose the verdict form, and the Bailey side of the case did not object to this verdict form. So
Do they have to make a specific objection to the verdict form if the objection is already within the scope of the objection they've been raising to the instructions?
I believe they do under the facts of this case, because the question is, was the jury properly instructed under this pattern jury instruction? And it goes back to the question of, are there material issues of fact about the dominion and control of Sonya Wright? And if Aunt Vondie drafted the beneficiaries in this case, and that's really what this is about, then...
But if it's a question for the jury, how can the trial judge put on the verdict form, Ralph Ray Bailey has the burden of proof by preponderance of the evidence? Isn't that answering the question for the jury? I mean, it's not. The presumption's overcome in this case, and that's why Bailey has the burden.
It's not, Your Honor, because when a will has been properly executed, the presumption is that it's valid. So therefore, the trial court, for them to shift the burden of proof, they have to prove by preponderance of the evidence that Ms. Wright was active in causing the will to be made. So they have the burden of proof on the first question. Then you also have the second question in the instruction, which I think is very important to consider in this case, which is, if the jury finds that she was active in causing the will to be made, jury, you should shift the presumption. And then Ms. Wright has the opportunity to prove by clear and convincing evidence. Again, the jury is presumed to follow the instructions.
So it was established there's an attorney-client relationship between Ms. Wright and the decedent, correct?
That's what the trial court held.
And
yes.
the nature of that representation or relationship was the purpose of preparing a will?
Yeah, getting the will typed out according to her suggestion.
Had there been some problem with this will, the decedent would not have, in her lifetime, would not have sued the legal secretary who typed it up. She would have sued Ms. Wright, correct?
Well, presumably, yeah.
I still don't see how Ms. Wright did not play a role in causing the will to be made here.
Because she did not, it doesn't say played a role. It says active in causing the will to be made. That sentence has to mean drafting the will and executing the will. Otherwise, every single time you have a beneficiary who's a lawyer who
So a malefactor could avoid liability by drafting a will and then letting their victim or mark go off and execute it elsewhere.
Well, but in the estate of Link case, it was a lawyer who made himself the sole beneficiary in the will, and he drove the person to another lawyer's office, stayed outside, and he drafted the will, and the trial court properly found that was an issue for the jury because it wasn't clear that there was coercive conduct so strong as a matter of law that overwhelmed the free agency of the testator, and that is what is missing here. If there's ever been evidence that Ms. Wright did not exercise dominion and control over Aunt Vondie, is the fact that Aunt Vondie took this will, ignored her advice, and with her husband they did two wills, and all the people at the Farm Bureau were friends and co-workers of Uncle Dan, and they expressly said that she's fine, she's normal, she's behaving in the way she always did. She walked in, she walked out. So that, and since Ms. Wright not only wasn't involved in that, she didn't even know they had done that until a year and a half later. So that blows up the idea that the presumption must shift because of undisputed facts that she exercised extreme dominion and control, and that's what's missing here.
Doesn't active is a broader term than just drafting the will, isn't it?
Well, I don't know.
I mean, you can be active by, say, referring it to your assistant to do. Could you not?
Yes.
Okay. Well, what I thought I heard you saying is she had to draft it, and that's not necessarily the case
Well,
under the word
It's-
active.
well, it's active in causing the will to be made. A will is not made when it's drafted or when it's delivered to the testator. It's made when it is executed, and that's when the presumption that the will is valid kicks in.
So the dominant party, under your conception of the law, has to have a role both in the drafting of the will and in its signing.
I think the case law in the State versus Link and I think it's Chambliss case makes it.
Did the lawyer
Chip-
in
Chip-
Link draft the will, though?
He didn't, and he.
Right, I mean, isn't that the critical difference between the two cases? And here, the lawyer drafted the will, and the final will that's signed is the will that Ms. Wright comes and hands to Ms. Smith, and that's the will that's signed, whereas in Link, the lawyer's not the one actually drafting the will.
Well, here, the key points in the will, the only thing that benefited Ms. Wright as far as the will was drafted by Aunt Vondie with her handwritten changes.
Well, except the ad interim clause, which would result in her getting more of the estate if anybody challenged it. I mean, that apparently did not come from the decedent.
Well, the problem with that analysis, Your Honor, is that the interim clause would benefit any potential beneficiary. At that time, everybody was still alive, so Uncle Dan could have challenged the will, or Ms. Wright could have challenged the will, because after all.
But you don't dispute that Ms. Wright is a potential beneficiary of that provision.
The way it played out, she could have been, yes, but at the time it was drafted, it doesn't show that she's exercising a dominion control over Aunt Vondie to benefit all the beneficiaries. And that, to me, is just another fact that shows why the jury had to make the decision about whether Ms. Wright was active in causing the will to be made.
All right, I want to go back to the verdict form question, because I'm still struggling with that. Let's assume for purpose of argument, you're right about your entire argument up until the, I'm still tripped up on the verdict form. It looks to me like the trial judge has answered the question and said, you know what, the burden is going to be on Ralph Ray Bailey. So, and how, even if you're right about the rest of this, how is that verdict form not an answer to the jury's question? You're supposed to figure out who's got the burden, whether presumption applies, but the right answer to the question is A, it's Ralph Bailey's got the burden.
When a will has been properly executed, and it was in this case, and that's not even an issue on appeal, there's a presumption that it was done validly. The only way you shift the presumption to undue influence is to show that the facts are so clear that a jury can't even answer the question of active and causing the will to be made. So therefore, the jury verdict form has the question of preponderance of evidence. Again, this wasn't objected to, because at the time that the jury got the case, it was presumed valid because it had been properly executed. So the next step is, what are the facts that show that it was actively causing the will to be made? Are they so undisputed that a jury simply can't get this question?
But there's no dispute in fact here, is there? I mean, we know Ms. Wright presented the handwritten notes to the legal secretary, was a shared legal secretary with Ms. Wright's law partner. Presumably the legal secretary came up with the additional language that was added to the decedent's handwritten notes, and then the will was taken to Farm Bureau to be executed. There's really no factual dispute, is there?
Well, but in the concept of undue influence is what is in the testator's mind. Is their free agency so overwhelmed that we can't let the jury make the decision? That is exactly the kind of mens rea that a jury has to decide and not a judge. But also I have to say that there's another way of getting to the result that we want, because 11.39 also raises this issue of, let's say the presumption shifts according to the jury. So then we go to whether Ms. Wright proved by clear and convincing evidence that the making of the will was not the result of undue influence. And then that kicks
Well,
in.
the problem with that, though, is we're asking the jury then in the course of the case to make, after the case has been submitted to the jury, to say, okay, at some point in this trial, the burden must have shifted. And, I mean, I found that very problematic from a practice standpoint.
Juries do that all the time in undue influence cases. I've tried them several times, and they always have this issue of clear and convincing evidence and shifting burdens. There's always two questions or more of shifting burdens that the jury is given. So that's a normal issue in a case. But here, there's overwhelming evidence that, because when you get to the second question, you get to the fairness of the transaction. And here, the fairness of the transaction was overwhelmingly Ms. Wright's side, because there was no question that she was very close to Aunt Vondie. All these witnesses, including Aunt Vondie and Uncle Dan, testified while they were alive that they wanted Miss Wright to get this. So you go to the fairness in the second question, and the jury could have found, we don't know, that the presumption was shifted, but this issue went to the jury properly as well. And they don't even have an argument that that wasn't properly in front of the jury, because there was a 11.33 and 11.34 shows about how testamentary capacity goes and how this all went. So this second question, since it was properly submitted to the jury, answers that question. So I don't think I don't think the court was putting his thumb on the scale, respectfully, Your Honor, by doing this, because after all, it is presumptively valid once it's properly executed, and then the jury must shift the burden. That is simply the way the undue influence law works in this case, and Estate versus Link makes it really clear that's the way it works, and I think that case answers almost all the questions in this case.
Well, your time is up. Thank you.
Okay, thank you.
Mr. Anglin?
Your Honors, I have limited time on rebuttal, but I do have two issues that I wanted to address briefly here. One is that Appellee stated that our argument is that in all cases, when there's a confidential relationship and a benefit, there's a presumption. Essentially trying to paint our argument as to be that this activity requirement is never required, and that's not the argument that we're making here. We're making the distinction between non-fiduciary relationships where that additional showing is required, some activity on the part of the beneficiary in the preparation or execution of the will, such as to show dominion over the weaker party, as opposed to fiduciary relationships where the law prohibits gifts or dealings between the parties. In those circumstances, in all cases, in the entire jurisprudence that we looked at, when the fiduciary receives a benefit, there is an automatic presumption of invalidity to the transaction pending that fiduciary's proof of clear and convincing evidence as to the fairness of the transaction. And that is the legal argument that we are putting forth, that because of that legal presumption that arose, there was no additional showing requirement of activity on the part of the beneficiary in making the will, and that this was a legal presumption that should have been charged to the jury and shifting the burden of proof.
Opposing counsel says there was no objection raised to the verdict form. Is there an objection? I'm assuming that's perfectly accurate that there was no objection to the verdict form. Is there any objection in your view that would cover an error on the verdict form?
Yes, throughout the trial, we had consistently raised that the presumption should be made and the burden should shift. We noted that objection at the end of proof, and the court denied that. So based on the denial of that legal finding, the verdict form had to be what the verdict form was going to be, because we didn't get the presumption found in our favor. We didn't get the burden shifted. The court made that legal ruling, and that's the objection that we preserved, and that's the argument that we're presenting here today. And taking that a step further, even if the court were to disagree with us about this distinction between fiduciary and non-fiduciary relationships, as Your Honor pointed out, even if you have the standard, which was actually stated in Kelly v. Allen in the terms of the activity required, some activity on the part of the beneficiary in the preparation or execution of the will. So even if the court were to not say, I don't agree with this legal conclusion regarding fiduciary relationships, you still have undisputed facts that show that she prepared the will, which would fill that element and shift the burden and make a presumption of undue influence arise. Again, appellee also raised in re estate of Link. Again, Link did not involve a lawyer who acted on behalf of Miss Link. Mr. Lane was Miss Link's nephew. Miss Link executed a will in 1998. Miss Link was an attorney who was a judge, but he was her power of attorney. All the court held in Link was applying the principle of Childress v. Curry to say there was an unexercised power of attorney. Because this power of attorney was unexercised, it did not create an automatic presumption of undue influence, and therefore the burden did not shift.
Thank you very much.
Thank you, Your Honors.
Thanks to all of you. Would you call the next case, please?
Metropolitan Government of Nashville and Davidson County versus Off the Wagon Tours LLC et al.
May it please the court, my name is Brian Kroll and I represent the appellants Off the Wagon Tours and Curtis Carney. I'd like to reserve 2 minutes for my rebuttal.
2 minutes?
2 minutes, yes.
Okay.
Before Nashville was the bachelorette party epicenter of the universe, Curtis Carney took a chance on a novel tourism idea, a tractor-drawn wagon to ferry visitors through downtown. He became, in many ways, the pioneer of what the General Assembly and Metro now calls the Entertainment Transportation Vehicle, or ETV, industry. This is even after, so in the original part of this, he could not be regulated because the statutes in question did not include entertainment transportation vehicles. When the General Assembly amended that by Public Acts, Chapter 666, they included specifically a wagon pulled by a tractor. Not before this court is a whole lot of other cases that involved whether you could register a tractor and all these other things for driving on roads, but ultimately, when they decided, the General Assembly decided to regulate these particular vehicles, they began wielding that power essentially with arbitrary deadlines to file permit applications and things of that nature. So what became regulation became the power to enjoin without any statutory authority whatsoever.
Counsel, I want to start with asking you about what we have to decide in this appeal. You filed a notice of appeal from the holding of criminal contempt.
Yes, sir.
And then you filed what you characterize as an amended notice of appeal after the court entered its permanent injunction. Is that appropriate procedure for getting the permanent injunction? I mean, why wouldn't you file just a separate notice of appeal to initiate a second appeal?
I think one, for judicial economy on this, I don't know if having 2 separate appeals and then consolidating them really changes the things, but we're only allowed to challenge in this appeal the contempt finding under the specific rules. So there's other things down below that may come up again in the
So
future.
you would agree that we're only then looking at the criminal contempt in this appeal? We don't have to worry ourselves at this stage with the permanent injunction?
Well, Your Honor, I think those are intertwined because when you have, under the Convalinka case that we've cited, a finding of criminal contempt is, the first part is to look at whether or not there was a lawful order. That's the first element.
Well, we could certainly find that the temporary injunction may be for a reason unrelated to authority. For example, that the issue about the bond was not appropriate and rule in your favor of criminal contempt and never really have to deal with the injunction, the permanent injunction, correct?
Well, I think if we find that there is no injunctive authority from Metro here.
Well, I'm talking about on another basis. Let's say we agree with your argument about the bond, nothing to do with the authority. That wouldn't necessarily touch the permanent injunction, would it?
Well, and I know they argued this down below where, because the way the text of the rule is, for Rule 6504, it says a temporary injunction may be granted if the bond is posted,
But for a permanent injunction.
Well, counsel, I guess what I'm getting at is, was the permanent injunction order properly certified under 5402 as a final judgment for purposes of appeal here? I mean, it seems like there was just one claim, there's one cause of action asserted in the verified complaint here, and there's several remedies. The court's only addressed one of the various remedies that Metro sought here. So why is this an appropriate case for certifying that order as final for purposes of 5402?
I think some of this was belt and suspenders to try to make sure it got up here, because I know the trial court was very concerned about having to even go through these criminal contempt proceedings.
Well, I guess I get back to my original question. You have any objection with us picking either the belt or the suspenders here, rather than belt and suspenders?
Well, and I guess I thought the court would go the other way, rather than get to the bond question and get into the overnight transportation company case. Rather than touch that, it could just find that Metro didn't have the authority, or this remedy was unavailable. But I think that with the permanent, if the original finding was there was no bond, therefore there could be no contempt, arguably the permanent injunction could still stand under
Okay.
that.
I'll accept that as a yes then, counsel.
I think we would, of course, prefer them all to go away, obviously, but I think the rule, although it doesn't expressly require a bond for a permanent injunction, in the normal course of how this would work, you would have first the temporary injunction with the bond and all that, and then you could consolidate that on the merits and have a trial on a permanent injunction. You can do it that way, but there would still be a bond posted. And this is because of the due process rights of those that are enjoined. I mean, you've got a business here that was shut down and now it's gone away. So he's had to sell his tractors, all that's gone. And that's because of this injunction. Subjunctive powers are the power to destroy. It can be.
Counsel, in your argument, you referenced the idea of localities not having power unless granted by the state, but it's a state court that's issuing the injunction here. And am I understanding your argument correctly in the sense that it's not so much that Metro doesn't have a power of injunction, because Metro is not issuing any kind of injunction. It's that the statutory scheme, Metro Code, doesn't authorize Metro to seek an injunction. Is that a fair framing of the discussion?
That's it, and this was very hard to phrase, because was it an issue of standing? Was it an issue of subject matter jurisdiction? Was it an issue of remedies? At the simplest, it fails to state a claim upon which relief can be granted here, because this particular injunction is
Well, but
not
the
available.
statute and the ordinance were both adopted in a world in which Rule 65 existed. So why wouldn't we presume that the drafters would think, well, we don't really have to include language specifically about an injunction because Rule 65 is there just for this purpose?
Well, we can't presume that the extraordinary remedy would be available. When you look at these
Well,
other
doesn't the
statutes.
statute say every municipality or governmental entity is hereby expressly authorized and empowered to control? It says controlling.
Controlling, well, and this goes back to the farmer's case that we cited, which says that the power to regulate is not the power to restrain trade, per se. And
What about the fact that circuit courts by statute have the authority to issue injunctions?
Well, there's a distinction between judicial authority and the municipality's right to seek this remedy. So sure.
Isn't the exercise of authority coming from the judiciary here? I mean, it seems to me like it's a state court. I mean, I know you cite some authority involving municipal courts, but this is a state court that issued the injunction. So,
Right.
And a lot of the argument in terms of localities don't have authority, and as Judge Bennett was just noting, a state court has an authority to issue an injunction.
It does, if that remedy is available for the particular cause of action, because not every cause of action here. We start with two different principles here. One, and one of the other 100-plus-year-old cases that I've cited in my brief, equity does not enjoin misdemeanors, right? This is not if there's a misdemeanor, there is no equitable jurisdiction over that. So that kind of starts moving us outside of the realm of this. But you look to the text of Rule 65 itself, and it says that a party's rights have to be violated, or are being or will be violated, but a municipal corporation doesn't have any rights.
So if we were to adopt your argument that there's no authority under either the statute or ordinance for the issuance of injunction in a case like this, do we have to overrule Metro against Jones?
That was my case too, Your Honor. That was, Mr. Jones was my client. I don't think you do, because in that case, and I don't remember if it was expressly stated or implied, but there's 2 cases that came out, Jones and then 6 months later, the other one. That is a zoning, short-term rental property is a zoning issue. And there's an ordinance that allows Metro to seek an injunction for zoning ordinance violations. You look at the dozen or so other statutes that we've cited, and it all requires that there be an express grant of injunctive power to the agency or the municipality, such as environmental violations. And in those codes, you usually see something along the lines of the agency can obtain a injunction, the municipal attorney, whoever has the authority or the standing to seek the injunction, and there shall be no immediate or irreparable harm needed to show other than the environmental violation itself. And I think the reason for this is not stated in any case that I could find, is because Rule 65 simply doesn't work for agencies and municipalities that don't have rights. So
They have rights to enforce the statute, don't they?
they have a duty. I don't think it's a right. They have a duty to enforce the statute, and this statute, particularly the General Assembly found that $50, well, they allow them to regulate it. It's our Constitution that limits it to $50 fines for a small offense.
So the practical effect, though, of your approach here is that violating an ordinance could really mean nothing. It's just a cost of doing business. I mean, most of these businesses, I think, could bear $50 per occurrence, could they not?
Well, it's a lot more than that. So they're allowed to $50. It's each on a continuing violation
Each
each
occurrence,
day.
right, yes.
So here, in the citations below, it wasn't just
So
operating without a permit.
you charge each bachelorette whatever percentage of the $50 as part of the fee for riding the wagon.
Well, so when you look at it, you stack it, $50 for not having the permit, another $50 for not having a permitted driver, another $50 for, Metro basically had 5 or 6 that they were going after per violation. They had, I think, 4 tractors operating. So very quickly, these fines could be thousands of dollars per day. The issue down below was that they never actually served these citations properly on Mr. Carney. So Metro needs to first follow its own rules and give that a chance before it can say we have immediate and irreparable harm. Moreover, the remedy itself, the $50 fine, demonstrates that there is no injunction needed. I mean, this is damages, much like if I've got rent and a landlord, landlord's entitled to rent, he can't enjoin his tenant because the rent is the damages that they should be entitled to. So very quickly, business decisions here could be, well, we better get our permit. Now, again, there's an arbitrary deadline. It's random. It's not every year. They don't do it on April 1st of every year. They email it out in short notice, and then all of these companies have to go.
So you haven't raised a due process issue for purposes of this appeal, right?
Well, I think
That's not before us.
that particular aspect is not before this court because I'm limited just to the contempt and the injunction. But these injunctions also invoke due process issues themselves because of his right to run a business and his right to.
I mean, your argument, you want us to go behind the injunction and say, well, there not a bond here, and the proof was insufficient. But, I mean, it's a valid court order until it is set aside, so didn't your client have a responsibility to abide by it? Even if they disagree with the underlying basis?
Well, it has to be a lawful order. When we look at this, without a bond, he's got employees, he's got people that have, it's more to it. It was also a protest where he was trying to get publicity on this issue.
So a little civil disobedience is what you're saying.
Yep, it was there. But it wasn't malicious. It wasn't something of that nature. It was for a purpose. So,
Counsel, is it all lawful, or is it just subject matter jurisdiction limited under Combalinka in terms of the order? Do you have to show there was no subject matter jurisdiction, or could you show the order was unlawful but that there was subject matter jurisdiction?
I believe Your Honor is getting at whether it's void or voidable at that. Our position is it's void ab initio. That would.
So what would be on the face of this injunction that would tell you that it's void? I mean, how would you be able to tell on the face of it? Because that's what's required to say something's void.
Well, it is and it isn't. You can look at the face of an injunction and say it's void by there not being a bond on it. Now, that should fall on the parties seeking the relief. The burden's always on them to comply with the rules. But Rule 65 sets this out as a condition precedent. To be honest, I haven't noticed if it's a majority of cases, but a lot of cases in other states hold this way entirely. I know that's kind of mentioned in the overnight transportation case, but if it's void ab initio, then he doesn't have to go back to jail. If it's voidable, then he still had to abide by the injunction order. The contempt still stands, and this court could find that he still has to face the consequences for that, but that the injunction underlying it was improper. The better argument, based on what we've got with this issue of standing intertwined with subject matter jurisdiction, is we look to the straight express facts, the express statements, of what the enabling statute allowed, what Metro ordinance, what it passed. And we're only asking this court to hold that Metro has to follow its laws like every other municipality. A finding for us is really nothing more than, you have to abide by your own rules.
Your time is up. Thank you.
Good morning, Your Honors. Kate Pham for the Metropolitan Government. I'll start with what is the issue before the court. It's Metro's position that the only issue before the court is the criminal contempt order from, I believe it was November of 2023, that original criminal contempt order. And specifically, the issue is whether that criminal contempt order is being attacked through the question of whether under the temporary injunction order that was issued by the circuit court was
And so does Metro
order.
have any position about whether or not the permanent injunction was properly certified under 5402?
So I looked at it pretty closely because it was a big record, but my understanding is that the permanent injunction was issued through an order on December 17th, 2023. It was never listed. That particular order was never listed in any notice of appeal. It was not even mentioned in appellant's briefing, the permanent injunction being issued. And there was actually a second criminal contempt finding for another set of violations that was also issued in that order. That is also not addressed in the appellant's briefing at all. So it's our position that.
So you're not worried about the 5402 part. You're saying that based on the original notice of appeal, that's what you're saying is limited to. But what about the subsequent amended notice of appeal, the new notice of appeal filed in this very case?
I think that
Do we just ignore that, or how does that work?
No, I think that I think it's been properly appealed. I think the problem is it hasn't been addressed. There's been no argument made about the permanent injunction or the second criminal contempt order. There's been no arguments made at all. Unless you're, other than the fact that obviously the appellant is challenging Metro's authority to seek injunctive relief in general, the procedural history laid out in their brief doesn't even address that those events occurred. There's no reference to the permanent injunction at all, and there's no reference to the second findings of criminal contempt. So it's our position that to the extent that obviously the authority of injunctive relief, if that's the issue that is the court ultimately rules on, that potentially that could affect those orders, but they have not been argued by appellant. And so it's our position that that's waived. But also, really the only issue before the court here is whether the circuit court has the authority to issue injunctive relief in a civil case that's for violations of the Metro Code. And appellant's argument is basically that if the statute that allows the Metropolitan Government to regulate this activity, if it doesn't specifically provide for injunctive relief, and the Metropolitan Code doesn't specifically provide or list out injunctive relief as a remedy, that means that injunctive relief is not available. And that's just simply not the law. It's conflating some basic judicial principles of subject matter jurisdiction, standing, and cause of action, the creation of a cause of action, and remedies. It's conflating them all into one thing. But these are distinct concepts, and you can look at it distinctly. So the first question of a cause of action is, and who has standing to bring a cause of action, that's addressed in Tennessee Code Annotated 73501. It's what provides Metro the authority, any metropolitan government, the authority to issue a civil warrant or a citation for violations of the Metropolitan Code. That is state law. So then the metropolitan government, through Article 2 of its charter, basically says that Metro is vested with that state law authority that exists.
Counsel, do you disagree that the Metro Code itself only addresses the $50 fine here? And there's no language in there that addresses an injunction within the, I understand you're saying there are other provisions beyond that authorize, but the code itself only addresses a $50 fine, right?
That's correct. The code does not specifically address that injunctive relief is an available remedy.
You've been laying out the regulatory approach then. The only thing that's specified is the $50 fine. Why shouldn't we understand it as it's the only thing that's within the scope of how Metro is regulating this as a $50 fine?
Because the metropolitan government is not limited. So it is a creature of state law, and state law provides other vehicles. The regulations set out the rules. How lawsuits are filed are set out in state law in different ways. So in this case, 73501 sets out that any violation of the Metropolitan Code can be filed as a civil warrant or citation in General Sessions Court.
Well, does the Metro Code, though, mention specifically injunction and remedies in other code sections?
Not this type of injunctive remedy, because this is a remedy that's basically, it's a very general injunction. We're talking about something like they're continuing to violate the law, the ordinance, and refusing to stop, and this is an injunctive relief. The request was basically that they cannot continue to operate without getting a permit, that's all it is. That is a general right of any litigant bringing a civil action to request injunctive relief. It's provided by the power that's in the circuit court, and here there's actual language giving that right to the environmental court for its jurisdiction. So here, this case is a little bit different from from the Jones case, and
yeah, I mean, why couldn't we just distinguish Jones on the principle that involved a different ordinance?
Well, I will say that ordinance does not provide for injunctive relief specifically inside the ordinance.
Well, maybe that wasn't
either.
really an issue about the ability to issue injunction.
What was before the court, though, was the question of whether that was a lawful order, and that was raised before the court. And that their injunction that was, in that case, the injunction was was actually issued by the environmental court and then appealed up to circuit. And I believe the contempt finding was upheld in circuit court. But this court ultimately determined that the environmental court does have the authority to issue injunctive relief, specifically to prohibit Mr. Jones from operating this business, which his business was a short-term rental, without a permit. It's the same set of circumstances. And there's also the Printer's Alley Theater case, which was sexually oriented businesses who didn't have licenses, and the court addressed it there as well, that the environmental court has that authority. It obtains that authority just through the general idea that general sessions courts have the authority to issue injunctions, just like the circuit courts do. And also, the environmental court actually has, in the Public Act creating the Davidson County Environmental Court specifically says that it has the authority to issue mandatory and prohibitory injunctive relief for violations of the code. So what appellant is basically saying is that you have to, for every case, lay out every remedy available in a statute or in an ordinance, but that's not the standard It might be for a criminal case. There's some citations in the appellant's reply brief about criminal sentencing. If you had a criminal sentencing, there might be notice issues at issue. But here, we have no notice issues. We have the Metropolitan Government, the original civil warrant that was filed specifically requested injunctive relief, an order prohibiting them from continuing to operate without a permit. Then when it got up to the circuit court, when it was removed, a motion for a temporary injunction was filed. Briefing was done. Everyone was able to brief that issue. And then the court issued that order, a temporary injunction through 6504. So it sounds like to me is that the appellant is asking for governmental entities to be treated differently from other parties. Because if you look, for instance, at the Vintage, I want to make sure I get it right, Vintage Health case, which was a 2009 Court of Appeals case, that was a breach of contract case. But ultimately, the court sua sponte issued a permanent injunction against the plaintiff in that case. And while the Court of Appeals didn't uphold everything, they let stand a permanent injunction specifically prohibiting that particular employer from threatening to report employees to immigration officials. That's obviously not something that's laid out in the statutes related to breach of contract. But it's because the court has the authority, the circuit court has the authority to issue injunctions. That's an authority that's given to the court. Here, there's no reason to treat the Metropolitan Government differently. The case law is clear that just like other individuals, private individuals, it can be irreparable harm to the Metropolitan Government if an appellant is openly disregarding the Metro ordinances. That can harm Metro. That invasions into the sovereign interest of the Metropolitan Government or of the state or of any governmental entity, that in its enforcement of its laws, those are not redressable by money damages alone. If we're talking, the slippery slope we would go down here is essentially what Your Honor pointed out, that these individuals, these businesses, could simply make this the cost of doing business and would be able to just continue to operate.
Well, I mean, the slippery slope works for the remedies too, does it not? I mean, fairly clearly, Metro can oppose up to a $50 fine. But one of the things that Metro's asking for is disgorgement of income. I mean, where does that authority come from?
So that's not. I don't believe that's actually before the court.
It's not, but it's a different. It's among the remedies that are being sought here, including injunctive relief, which we are interested in. And so I'm trying to figure out, well, where's the authorization come from all that? I mean, where does disgorgement come from?
I believe that was requested in the complaint. It hasn't been addressed yet by the court at this point. What the court has requested, what's been reserved at the trial court level, is the question of the $50 fines. So how much would this actually be? How many times was the law violated?
So it sounds like you might be conceding that Metro's asked more than it really might be entitled to.
For disgorgement, I haven't briefed that, and I wouldn't want to answer that without having more information on it. So I will say, though, injunctive relief is something that this court has upheld time and time again as something that the Metropolitan Government and other governmental entities can request. And of course, not every statute or every ordinance is going to specifically state that if you keep violating this law, we may ask for a court to stop you. That's essentially what the appellant is arguing, is that we have to, in the Metro Code or in state law, specifically say that if you keep violating, we might ask the court to enjoin you. That is just not something that's required for civil action. Because the only reason you would think that would be required is for notice purposes. And notice purposes in a civil action, that's provided by the rules of civil procedure. And that is what Rule 65 handles for temporary injunctions. The standard is set forth, and there's no dispute as to the underlying facts here. I also think that's important to note, that the underlying facts of this case there's really no dispute. The appellant did not have a permit, did not obtain a permit, continued to operate without a permit, even though there was citations issued by the Metropolitan government. I know there's some dispute about whether they were served, but there's no dispute that that the appellant knew about those citations and that was operating even though the citations had been issued. There's also no dispute for the underlying factual findings in the criminal contempt order, that even after the temporary injunction order was issued, that this business continued to operate for months. And really the only thing that's being challenged is the idea that the Metropolitan government should be somehow treated differently from other litigants in a civil action, that it should not be allowed to ask for a temporary injunction under Rule 65. And that, I don't know how you get there. I do also want to point out that there's some statutes that are listed and some cases that are listed in appellant's briefing. And if you look at those, what those really get to, for example, TCA 375-508 is related to the Department of Children's Services and its ability to enjoin unlicensed operations. But what that actually is a statute creating a private right of action with giving DCS the standing to bring an action. We don't need to do that here because that's already been created in Title VII. And so we have subject matter jurisdiction, we have standing. The question is remedy, and remedy is provided by Rule 65 and also just by the Circuit Court's authority. Thank you.
Thank you. Mr. Kroll?
Just briefly, Your Honor, there is a dispute over the citations being served properly, and as this court's aware, for there to be proper service, that has to be, for notice to be deemed effectual, there has to be proper service. None of these are signed, none of these are there. I don't know if this is in this record, but they also had unserved citations that they were planning on still using, and even writing additional ones using the discovery.
We don't have the notice issue before us in this case, do we?
Well, only to the extent that it attacks their claim of immediate and irreparable harm. This court should not reward Metro's missteps with service of citations with injunctive powers that are not given by statute or by ordinance.
Well, when we're looking, though, under the Kombalinka factors, whether or not we have a lawful order, I mean, do we go behind the actual order itself at all? I mean, it sounds like you're asking us to look back to original service on the lawful order. Is that an appropriate part of the inquiry?
The order, I mean, we were in court.
And otherwise, you open up the entire case on the criminal contempt finding, or civil contempt for that matter.
Well, yeah, I mean, we were already in court at that point when that one came through, but it's interesting when Metro cites the section 1402 of the charter as their basis for being allowed to do this. That charter provision actually says that the General Sessions Court has exclusive jurisdiction over ordinance violations, which runs into other issues that we're not really dealing with here today. But the issue is whether or not Metro can seek an injunction. They should be treated differently than regular parties. One, they don't have rights. Two, they're municipal corporations that are creatures of statute. They only have the powers, we're talking about invasion into their sovereignty, they only have sovereign powers that are granted them by the state.
You couldn't dispute here, counsel, could you, that had either party been, if this matter had remained in Sessions Court and either party been dissatisfied by the judgment there, they would be able to seek an appeal to Circuit Court, correct? Which is exactly where you ended up.
Yes. Yeah. That is an important statute, but there's conflicts here with how they want to do it. And the bottom line is, they have to at least attempt to have an ordinance that gives them this power. I mean, the ordinance is the fuel and the vehicle that drives Metro. I mean, they can only do what this ordinance is in their charter or other statutes, since they do have the home rule issue. All that means is you don't necessarily have to pass more ordinances for other general laws, that the General Assembly passes. But when there is no injunctive authority, period, a decision in favor of allowing Metro to have that is going to turn over all of these other statutes, like the DCS statute, which says that they can go and join.
Right, your time is up. Thank you.
Thank you.
Thank you both. I believe that concludes today's docket. Would you adjourn court?
This court stands adjourned.